To thank and to commend all three speakers for their papers. We have about 15 minutes or so for any comments, any questions, queries, observations, or anything like that. I'll open it to the floor.
Professor Quinn mentioned there about the Privy Council, and I think at some point, I'm not sure which year, maybe you can tell us, De Valera passed legislation overpowering or usurping the Privy Council as an appeal court from the Irish courts. Was that could you see that as a kind of an enabling act in Ireland, in that you said, or to say the 1922 Constitution projected, if you like, undid the principle of parliamentary sovereignty, and this was seemed to be a reversal of that, because it was saying the Parliament could overturn the power of the ultimate appeal court?
No, I would say not. There was no handing over of parliamentary sovereignty to the executive in Ireland. I mean, it could have happened. For example, I think one of the judges in State Ryan against Lennon said, oh, and if he wanted to abolish, through the use of the extended amending power, elections or periodic elections or anything else, of course, be our guest. But De Valera didn't take up the invitation, to his immense credit. Likewise, you might say that the civil rights that were diminished by the decree issued by Hindenburg had an equivalent with Article 2A that was inserted into the Irish Free State Constitution, which essentially gutted all of the civil rights, but thankfully I think it didn't last very long. Maybe John could answer that one. So I don't really see a direct parallel in how Hitler used his powers to radically deconstruct all poles of opposition to his viewpoint versus De Valera, who actually preserved and maintained the form of liberal democracy, albeit with Irish characteristics. And those Irish characteristics, of course, are becoming more and more remote to us in the way Irish society has moved on in terms of the theocratic elements in the Constitution and so forth. So I'd see De Valera as a classic liberal Democrat who maybe couldn't show his cards as such at the time, but that's essentially what was happening.
Can I just make a point in relation to that as well, that if you're interested in the Privy Council, Tom's got a book coming out by the end of the year.
Thanks to all speakers. I have a question for Laura about the enthusiasm on the part of the 1922 framers for direct democracy. Well, to use a phrase that I don't like, but it's a convenient one. It seems to be that their abortive enthusiasm or their partial enthusiasm for direct democracy might be in tension with their social conservatism, say, because historically conservatives don't like direct democracy for all kinds of reasons. I forget which one of the Federalist papers it was in which James Madison opposed direct democracy, although I'm not sure if he used that phrase, referring to the risk of turbulence and particularly the risk to property, that empowering the people would undermine the established order and the established social order and the order of property. And is there any evidence that the framers of the 1922 Constitution were even aware of that tension, or in what sense was their social conservatism evident in that tension in the scheme that they actually enacted or contemplated? And I think the problem is in part that where direct democracy supposedly empowers the people, that the people refers to two very different things, at least in the history of political thought. One sense is the abstract unitary people, the sovereign or the constituent power, and the other, more historically, probably with more ancient roots, refers to the people as a social class, to the masses. And there's a particular hostility towards empowering the people in that sense because of the risk of empowering the propertyless against the propertied. And that's why I think the more Roman or the neo-Roman Republicans tended to emphasize a constitution which had some kind of equilibrium or balance between the propertyless and the propertied. So were the 1922 framers even aware of that tension in enacting direct democracy?
Well, it's interesting, first of all, there seems to be a clear divide between the sort of ideals and the views that the actual committee had, and then the views of both the provisional government and then the Constituent Assembly. Whereas the framers, they did really seem to believe in these ideas of direct democracy. Social conservatism, it doesn't really seem to have been an issue. I mean, there's no right to private property in the 1922 Constitution. They were very interested in the idea of promoting public property, actually, and natural resources of the state and the common weal, all this kind of ideas. You see it in the writings of Collins, but also some of the committee members. But when it went to the provisional government, and when you look at Cumann in particular, and members of the Constituent Assembly afterwards, they are certainly thinking of the interests of the property owning class, who they need to bankroll the economy, and a lot of these experiments get toned down at that stage because of the fact that they are thinking of those particular issues. I don't know, is that kind of what you were getting at?
Maybe just a comment on that. At the late Adrian Hardiman's funeral, Michael McDougall, in giving the eulogy, recalled meeting Hardiman Sr., the father, and having long conversations when, Michael and Adrian were both young men, and that Adrian's father always described himself as a Republican socialist. And Michael asked Adrian at one point, what exactly does he mean when he says he's a Republican socialist? And so with Susan Denham sitting in the front row at the funeral, I may add, Michael said, well, the answer that Adrian gave was, he's generally in favour of expropriating Protestants. So maybe that is part of the background of the debate about property rights as well, because, socialisation of property might have taken a particular direction in the 1920s in Ireland, given the historical enmities that existed.
Other comments? Questions? Observations? Evening?
I'll give an observation.
An observation, there you go.
It's an observation that concerns Laura's paper. I won't dress it up as a question. That really irritates me when people make a comment and pretend it's a question. It's simply the British perspective on the external ministers. They were unimpressed by the external minister's scheme. They saw it as creating a permanent oligarchy, because they said to the Irish, if what you say is going to be true, you're going to have lots of, multiplicity of parties, governments being rather short-lived, and the elected ministers, losing power, but the unelected ones staying behind. It's very dangerous. They said, they said, we're giving this to you as advice, we're not insisting on it. It's interesting. Also, the other comment I'll make is about the criticism made of the old Shannon elections, the only one held in 1925, that the ballot paper was colossal because the whole country was being used as a single constituency. I think I'm right in saying that the ballot paper in Galway West in the last election was well over half a metre long. Those are my comments.
They also had a problem with the results sheet, which was so big they couldn't find any wall to put it on, so they had to lay it out flat on the ground. It took 3 weeks as well to determine the result of the election, partly because they didn't really assign many people to count the votes, I think, but it still was several weeks before they filled the 19th seat.
Anything else? Any other? Yeah. And then.
Thanks very much for 3 very interesting papers. And can I ask Laura what you know about the selection of the people who are on the committee that drew up the Constitution? It seems like quite a motley group.
In the archives of the committee, there was lots of names being thrown about as to who would be members of the committee, but they didn't actually record who exactly they asked and who would have turned it down, and why they actually asked the people they asked. Maybe Tom would have some insight into that as well. I know they spoke about Tom Johnson, for example, being involved, and I know there was ideas about the bishops being involved at one stage, but then that didn't happen. But some of them were involved in an organisation called the Irish White Cross, which was a civilian relief organisation. I think there was about 4 committee members involved in that organisation, and it was seen as an organisation which would be politically neutral and suitable to all sides. So, for example, Douglas and France
CJ
were on the
France.
committee. I think a few more were associated with it. So that was one reason. Douglas was very good friends also with Collins. He pulled CJ France in, and Hugh Kennedy was legal advisor to the provisional government, and Kevin O'Sheil was also an advisor. So that explains those. Alfred O'Reilly was actually a late addition, so I'm not quite sure. Why they decided at the end all of a sudden to bring him in, but I don't know, Tom, maybe you have other information on that.
Alfred O'Reilly was brought in because he wrote an article which impressed Michael Collins. To a large extent, the people were picked by Collins and Griffith, and their choices, of course, weren't compatible because Griffith picked Figgis and Collins couldn't stand Figgis. In fact, one of the difficulties he had with Figgis is that Figgis actually he engaged rooms in the Shelburne Hotel without telling Collins, and Collins was furious. It's the most expensive hotel in town, and the embryonic state doesn't have a lot of money, so that's something they don't advertise in the constitutional room in the Shelburne. But equally, you could say that it was Collins who actually picked O'Reilly, and O'Reilly, again, didn't get on with anybody. That's one of the reasons why he drafted his draft C, because he just pulled out of the rest of the sessions, just went rogue, if you like.
You mentioned the George Murnahan, was it? Did you say? James Murnahan, yeah. Because he had been employed by the bishops earlier on to go through the third Home Rule Bill and to check it for any elements that would be detrimental to the Catholic Church. So it's interesting to see him crop up in this context.
I
as
didn't
well.
know. That's interesting. Yeah, Murnahan wasn't too involved in the drafting. He sided with O'Reilly in the end, actually, in the draft C, but he wouldn't have been heavily involved in the work of the committee. Besides, he worked in the judiciary provisions with O'Byrne, but besides that, he didn't really contribute very much after.
Let's talk about James O'Connor getting involved in the Constitution Committee, just to give some of the old judiciary a say, but that Collins and Griffith came together for once to squash that.
The question there, and then okay.
I'm going to attempt a provocation, which I think is halfway between a comment and a question, which is, so the Supreme Court judgment in State Ryan versus Lennon comes in for a lot of criticism, and in particular people say, well, wouldn't it have been good if Chief Justice O'Kennedy's approach had been followed and Article 2A had been quashed? I'm going to just suggest the opposite, that there is a cost when we allow judges to make these decisions, and we've got no particular reason at all to think that judges have any better sense of how a polity should develop than the politicians do. I can say this now, I think that the very last group of people you would want to have exercising any power in a country are the members of the judiciary. And what happened, we can't get into counterfactuals, but what happened afterwards is that we got a much better constitution, I think, that has functioned well since. And who knows whether we would have got it. We probably would have, but we might not have got it if the majority had taken the approach of the minority and decided that they had the power to make things better. Maybe it was better that they let things as they were and said, you go sort it out, which is, well, so anyway, it's a provocation, hopefully, to see if anybody wants to disagree.
I agree with you, so tough luck. Actually, one of the things that always struck me in relation to the secondary literature on State Ryan and Lennon is how everybody was convinced that it was a terrible thing that the dissent hadn't been acted on. I think that's actually wrong for a couple of reasons. First of all, I actually think the reasoning isn't particularly good. I'm not entirely convinced by the other members of the Supreme Court either, but if you look at the High Court, the judgments actually are a lot better. I think probably the Meredith judgment is my favourite anyway. But I think actually if you look at it in the context of the time, I think you could probably predict two things would have happened if the Supreme Court had gone the other way. The first one is that the Supreme Court itself would have come under immediate attack. So every institution of state that stood up to De Valera got crushed. he was at that point in time in the process of dismantling the Senate. So I don't think there would be any doubt but that he would have also acted against the Supreme Court at that point. And possibly, I don't know how he would have done it. He might have packed it, but certainly the kind of the legal consensus at that point in time was that if the decision had gone against him, he would have been within his rights to do this. So if you look at what Breedale Keith writes about it immediately afterwards, he says, well, look, if he lost the case, he would definitely have gone after them, and he would have been correct to do it. And I think that would have had the knock-on that there is no possibility that judicial review in the sense that it exists right now would have ever ended up in the 1937 Constitution. So what would really have happened is they would have won one case and immediately got hammered, and nothing would have ended up in 37. That would be my prediction of what would be the likely outcome of a system like that, because he was not prepared to accept losing these kinds of things, basically. So the argument I always think about Ryan and Lennon is, first of all, I think the decision was correct, although, as I say, I think the High Court decision is the better one. But I think also, from an institutional point of view, it was actually the best outcome that could possibly have been generated. But I know I might be on a minority in relation to this, but...
I think it was the best outcome, but we couldn't have predicted that at the time of the actual judgment. And I hate the way the case is reduced to positivism versus natural law. Really hate that. Because I don't think, well, first of all, the positivistic side of it, it's highly anomic if you read the other judges, the plurality in the Supreme Court. They don't draw down on any deeper theory of what anchors the Constitution, and one might say good, because personally, I don't want natural law entering into constitutional argumentation. But they were so anomic as to allow absolutely anything to happen. And I think that's a problem, and that's why people like Franz Neumann and others try to provide non-natural law-based arguments for judges to intervene in these extreme instances. It's obvious they didn't have the mental capacity to actually grasp that or articulate that, but I think that's what they should have done. In a sense, that's what the European Convention of Human Rights is trying to do, in my view.
Yeah, I agree with both of you in a way. I agree that Donald's prediction is probably true. That's probably what would have happened. But I disagree. I think Hugh Kennedy's reasoning is flawless. Not quite, no. But no, I do. I think he does actually provide a very interesting basis in popular sovereignty rather than natural law in terms of disagreeing with his colleagues. So I think that would have been the way to go.
Could I just quick supplemental here? I think it's fundamentally undemocratic. I think you can't justify it as against a democratic ethos. I think it's incumbent on us to come up with a theory that empowers the judges that is compatible with democratic theory. And to me, natural law is not that theory.
Just maybe a supplementary comment on that. To go back to Gerard's point about Article 2A, it did remain in force and in operation right up to the 37 Constitution. And part of Fitzgibbon's judgment is this sardonic mockery, this sarcastic, castigation of Fianna Fáil for their hypocrisy in having opposed Article 2A vehemently as a denial of fundamental rights, and then only a few months later, really, being willing to put it into operation. Because I think by that stage, Fitzgibbon was completely detached, really, from the new, like emotionally or psychologically. He was an old unionist who I think didn't have much emotional attachment to the new state, really, or a desire to project its legitimacy or, give credit for there being principles that were worth honouring under the Free State Constitution.
Just in relation to that, one of the things that happens is that the amendment clause, which allows amendment by means of legislation by a simple parliamentary majority, has got to be extended. And in the debates on that, De Valera says, I'm going to completely support this because when we get into power, we're going to abolish the Constitution. And then they say, okay, move the motion. And somebody, I forget who it was, says, going, gone. This is the end of the Free State Constitution. So they were warned. That's the only thing I'd say.
But to some extent, they give him credit for going ahead, knowing that would happen.
Yeah, I suppose that's true as well. But I mean, you couldn't say that De Valera used in a way that was, a surprise. So anyway.
We have a question at the back, and then we'll finish up with a question at the front. Is there a question at the back?
Yeah,
Oh,
yeah. Yeah, to the panelists there, because I'm not from a legal background, I used the term natural law. Could you kind of explain what you mean by that term? I don't fully...
Professor Quinn.
Oren, would you like to answer that? Well, it's basically a set of substantive norms against which you can measure, judge, or adjudge either a legal system or particular laws enacted within a legal system. The source can be varied. It can come from Catholic teaching. It can come from John Locke. It can come from Thomas Hobbes. It can come from Karl Marx. It can come from the East German Communist Party. And that's one of my problems about natural law. I know, Conor, you'll disagree. But, and so it's an effort to trump, basically, the regular democratic process. But, of course, that begs a lot of questions about the actual architecture of that democratic process and whether it's skewed toward particular results. Which is why I would say there are democratically based arguments for a Supreme Court to intervene, but not natural law based arguments.
I disagree. I think this is probably not the best forum for a discussion on natural law. I do have more sympathy for natural law than Professor Quinn, but at the same time I acknowledge the force of the practical difficulties. What version of natural law, where does it come from, and most importantly, who gets to decide which version we're going to use. So I do acknowledge those. But we'll maybe discuss those issues on another occasion. We have a question here at the front.
It's just actually a very brief observation, thinking about Owen's comment about referendum and popular democracy being viewed as a sort of destabilizing effect by conservative elites within society, which certainly would go back to Madison and so on. But I think it's important to remember, and this links George and Laura's papers, that of course by the 1920s the plebiscite had become a major tool for the fascist right across Europe, fascist or populist right. So Mussolini was deploying it quite systematically. In a way, incidentally, which has some echoes now about the proposed Hungarian referendum, for example, that Orban is invoking to override any EU deal on refugees, for example. I don't want to push the Orban-Mussolini analogy, but certainly by the 1920s, you had you certainly had the plebiscite being used, the appeal to direct democracy by both the fascist right and the left in a way that that perhaps to a certain extent influenced, though Laura would know much more about this than I do, the response of government in Ireland in the 20s and 30s, the sort of increased suspicion of it, which I suspect as the 20s and 30s developed, and as the plebiscite was put to increasingly questionable uses across continental Europe, would have probably reinforced a tendency to fall back on the established practices of British liberal parliamentarianism.
Yeah, I think you're right.
Any other last comments? Okay, we will call it an evening. I think it's been a very successful first day of the Constitution. I hope you will join us again tomorrow morning. We will be starting at 11 o'clock. There will be tea, coffee and bickies for anybody from about 10:30 onwards. And we'll see you tomorrow. Thank you very much.